Hello friends, very warm welcome to my Business Laws channel. Today is the second video to this LLP Act 2008. In the very first video, I have covered introduction to LLP Act, salient features of LLP, and then difference between partnership firm and LLP, and LLC and LLP. So this is the second video lecture to the LLP. Friends, in this video lecture, I'm going to take up the amendments. LLP amendments which took place in the year 2021. The amended provisions regarding name and change therein. So friends, I would like to discuss very important points. The first one is names which are not allowed. Earlier, before this Amendment Act, section 15 to 21 were regarding, regarding the provisions regarding names. Now, there also, some restrictions were there that the partners were not allowed to have any name. Some prohibitory words they were not allowed to use, or, some words they were allowed to use with the permission of the approval of the central government. And name should not have been identical with the existing LLP or company. So similarly, friends, there are some restrictions under this amended act also. So I would like to take up all these important points. Names which are not allowed. The LLP Amendment Act 2021 amended the section 15(2) by substituting the following matters. No limited liability partnership shall be registered by name which in the opinion of the central government is identical or too nearly resembles to that of any other limited liability partnership or a company or a registered trademark of any other person under the Trademarks Act 1999. Change of name of limited liability partnership. The LLP Amendment Act 2021 has fully substituted Section 17 of the LLP Act 2008 and also omitted the Section 18 of the LLP Act 2008. So Section 18 has been omitted and whereas Section 17 has been substituted. The provisions of amended Section 17 I would like to discuss now. The very first one is the central government power to change the name. This is given under Section 17, subsection 1. If the name of LLP is identical or too nearly resembles the name of any LLP or company, it is identical or too nearly resembles a registered trademark of a proprietor. The central government shall direct such LLP to change its name within 3 months from the date of issue of such direction. So whenever, friends, central government finds that the name is identical or, it is against the provisions of the act, so then in that case, the central government shall direct such LLP to change its name and LLP will be required to change its name within a period of 3 months from the date of issue of such direction. So all these directions are to be followed by the LLP within a period of 3 months. A proprietor of registered trademark is entitled to make an application to central government. So he is entitled to apply to the central government, that is the regional director, within 3 years from the date of incorporation of LLP or registration of new name in E-Form INC 23. So here, the application has to be made within a period of 3 years from the date of incorporation of LLP or registration of new name in E-Form, which is INC 23. So next is filing of notice to the registrar. This is the provision which has been contained under Section 17, subsection 2. Where an LLP changes its name or obtains a new name under Section 17(1), which I have just discussed, it shall, within a period of 15 days from the date of such change, give notice of the change to the registrar. The name has to be changed by the LLP and it has to be given, the notice of the same has to be given to the registrar. along with the order of the central government. The central government has given the order to the LLP to change its name. Who shall carry out the necessary changes in the certificate of incorporation? Then it will become the duty of the registrar to make required changes in the COI, that is the certificate of incorporation. And within 30 days of such change in the COI, such LLP shall change its name in the LLP agreement also. So LLP is required to make agreement, but agreement drafting is not mandatory. In case the partners of the LLP have decided to draft LLP agreement, then such changes regarding the name, they are to be made by the LLP in the LLP agreement also. Now the next, I would like to take up the next point, allotment of new name to LLP in case of default. This is a provision which has been contained under section 17, subsection 3, where a LLP is in default in complying the directions of registrar for change of name. The registrar shall, whatever time has been given to the LLP. Now, if the LLP has not changed the name within that specified period, then in that case, we will say the LLP has committed default. Then the registrar shall suo motu allot a new name to the LLP, which shall be ending with ORNDC. Now, ORNDC stands for Order of Regional Director Not Compiled. Regional Director will be the central government. It means the order of central government has not been complied with. The year of passing of the direction, serial number, and the existing LLPIN of the LLP shall become the new name of the LLP. The registrar shall issue fresh certificate of incorporation in form number 16A, and accordingly such name shall be entered in the register of LLP. Now this name, whenever the LLP has defaulted, this name will be entered in form number 16A. This will be entered in the register of, the same name will be entered in the register of LLP. Now the complete abbreviation ORNDC shall be mentioned by such non-compliant LLP because LLP has committed default now. Now below the name of such LLP on its invoices, office correspondence and publications till the time such LLP changes its name in accordance with section 19. Now one additional point I would like to share with you friends. Nothing in this section shall prevent a LLP to subsequently change its name in accordance with section 16 in future. And now the question arises, section 16 deals with which provisions? Now section 16 is regarding reservation of name by Indian LLP and foreign LLP. And now, I have used the term suo motu. The question arises, what is the meaning of suo motu? The Supreme Court of India has often taken up cases suo motu. Now, this means that they take up cases, the Supreme Court takes up the cases by their own notice, without any petition being filed or interest being brought before them. Even if no petition has been filed, or no interest has been brought before the Supreme Court. By their own notice, suo motu, Supreme Court has the authority to take up the cases. The 46 suo motu cases are lying in the Supreme Court from 1990 to 2021. So friends, in my today's lecture class, in this video lecture, I have covered all the provisions, regarding this name and change therein, which were provided under the LLP Amended Act 2021. I hope you all will like the content. And if you have any doubt, do write in the comment section. I will definitely answer. Do press on the bell icon to get notifications of my subsequent videos. Keep smiling and stay healthy always. Goodbye, friends. We'll meet soon.